Major breaking news out of the United States District Court for the Southern District of California. A judge has ruled that a switchblade knife ban is constitutional under the Second Amendment. Clearly wrong, clearly analysis done wrong. Lots of mistakes in this. And remember, sometimes people are put on this earth to teach us what not to do. I suspect that Judge James Simmons is exactly that when it comes to this decision, how not to interpret the Second Amendment as applied to an arms ban case, in this context, switchblades. Let's talk all about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. For those of you who got signed copies of the book, as a courtesy, out there at the Gun Owners of America conference, a great event in Knoxville, Tennessee. Let me know what you think about it when you review it on Amazon. If you're willing, that would be great. The good and the bad and the ugly, it's fine with me. I'd like to learn from all of that. All right, folks, so major case here dealing with switchblades, which is really just a knife, right? So all we're talking about is knives. Effectively a ban out there in California. We don't need to get into the niceties of the particular law in this case, but in the case of knife rights versus Rob Bonta, we have a district court decision here by Judge James Simmons, who is a Biden appointee, a 45-year-old Biden appointee to the federal bench, who clearly tried to interpret the Second Amendment and apply appropriate precedent, but messed it up 6 ways to Sunday. We'll get into that in just 1 second. But again, as a reminder, a switchblade is basically just a knife. That's all we're really talking about there. I didn't even think switchblades were particularly popular in the grand scheme, except in the years after West Side Story, the movie and the musical, which made switchblades kind of cool because of all the cool gang fighting between the Sharks and the Jets and all that. But we're really going back in time for entertainment purposes. Nevertheless, switchblades are very popular in the United States. The data that was provided in this case, with the judge accepted, is there's something like over a million switchblades that are manufactured and sold in the United States every single year. That's a really big number. I didn't know they were that popular. But nevertheless, we're not here to talk about switchblades and popularity per se. We're here to talk about, did the judge get the Second Amendment analysis correct in the context of an arms ban case? And the judge clearly got this bollocksed up entirely. So let's just begin from the start. The first thing that Judge Simmons says that was wrong is he specifically writes that right now, right here, the United States Supreme Court articulated a new analytical framework in Bruin. Totally wrong. Come on, let's go. Bruin does not create a new analytical framework. That is the sort of thing I would get from some journalist that doesn't understand the law, that doesn't know the difference between a federal district court judge and a court of appeals judge. No, Bruin reaffirmed the already existing analytical framework for interpreting and applying the Second Amendment in legal cases in America that was set forth in 2008 in the Heller decision, which deals with, drum roll please, Judge Simons, an arms ban case. And again, Heller said, if you look at the text of the Second Amendment and then the history of firearms regulations, when it comes to arms ban cases, the only conceivable historical tradition of regulation is restrictions on dangerous and unusual weapons. But here's the thing. From that history, what we know as a minimum amount of protection is if a particular kind of arm is in common use by Americans, meaning it's out there and common for lawful purposes, it cannot be banned. Period, full stop. And there may be other ways to protect arms, by the way, if you're dealing with a new arm or something like that. But we don't need to worry about that right now because switchblades are not new. They've been around and they're in common use. Nevertheless, the first thing, of course, the judge says, and you know when they go wrong, is that when they pretend that the Second Amendment jurisprudence in American life starts with Bruin. When all Bruin is said, and Bruin, remember, Bruin cites favorably to and reaffirms Heller literally, and I think I counted this in one of my articles in the Harvard Journal there, literally says and cites to Heller something like 85 times favorably. So Bruen is just reaffirming Heller and saying to the lower courts, hey, you guys, you screwed up Heller. We're going to now give you a paint-by-numbers approach to how to apply Heller. So the fact that Judge Simons here is literally saying that there's a new analytical framework for Second Amendment cases articulated by Bruen, which means you know you're already going off a cliff because you're so far wrong. It means you don't understand the jurisprudence that you're about to apply as a federal judge with lifetime tenure. Come on, get it together. Okay. Second thing is, another mistake that the anti-gunners are desperately trying to dupe these judges. And in this judge, he got duped. He says, remember, you start with the text of the Second Amendment as defined by the Supreme Court, very broadly, by the way. If the text is implicated by virtue of a modern-day gun control law, which when you're dealing with a switchblade ban, it undeniably is. And why do we say that? Well, Americans have a right to arms. A switchblade is obviously a type of arm. It's a knife. Okay? We know that arms, in the context of the Second Amendment's right of the people to keep and bear arms, is not limited to handguns. It's not limited to firearms. We know that because stun guns are not firearms. And yet the Supreme Court in 2016 said that stun guns are protected arms. So we know that arms is not just limited to firearms. It includes, obviously, the most common type of knife in all time, arguably maybe even more common than firearms, if you look at world history, human history, is knives, which is a switchblade, a knife. It's a knife, big BFD. It's a knife. I got knives in my drawers I can cut stuff with. Pretty boring tool. Been around for a long time. Okay? All right. Now that we know that the text is satisfied, here's the kicker. The burden shifts to the government. Now, why did I just remind you of that thing that everyone on the Four Boxes Diner world understands backwards and forwards? But Judge Simons, who's on the federal bench with lifetime tenure, doesn't get it. And this goes back to my point, folks, that if you follow this channel, I will make you smarter than federal judges and so-called scholars and intellectual giants at your community college that think they know more about guns than you do. I will make you better than they are. I will be able to turn you loose in a debate stage with federal judges, and you will generally kick their butt. And this illustrates the point. Okay? So Judge Simons goes on to say, and you'll see the terrible mistake he just made. He literally says on page 4 that the textual analysis requires, hear what I just said? The textual analysis requires a judge to find that a weapon is in common use today for self-defense. What? Do you hear what I just said? He says that at the textual level of the Second Amendment analysis, the plaintiff, meaning the Second Amendment advocates, have to find that an arm is in common use for self-defense. Totally wrong. Not even close. Come on. The text is the text. The Supreme Court has defined all the key words. The right of the people has been defined as all Americans, and maybe some green card holders, but all Americans with a connection to America. All Americans are the people. Then the arms are defined repeatedly by the Supreme Court using 18th century lexicographers, who are simply, lexicographer is a person that puts together a dictionary, using 18th century creators of dictionaries, both in America, in the form of Noah Webster, and in England, in the form of Samuel Johnson, and even in Ireland, by the way, but we don't need to get into that. But the point is that the Supreme Court defined arms as anything that can be used offensively or defensively, which obviously includes a knife, which means what? Once you understand that you're banning or restricting the use of a knife, including a switchblade, obviously, the text is satisfied. Hello, the text is satisfied. And why is that so important? Because once the law is implicated by the text of the Second Amendment, you know what I'm about to say, the burden shifts to the government. And here's the key. The in common use test, as we've talked about, and as you well understand, is not part of the textual analysis. The in common use test comes from the American history of firearms regulation, which occurs where? At the historical level of the text first, history second analysis, which means what? The burden is on the government to establish that something is not in common use. Hear what I just said? When you start getting, once the text is satisfied, which is very, very easy to satisfy as a matter of pleading, it's very rare for it not to be satisfied. There's some examples, but generally speaking, no can do. Certainly a ban on a switchblade is a no-brainer. If you're saying Americans cannot have switchblades, you're saying Americans cannot have knives, Obviously, that's the implication of the right to keep, which means to possess, and the right to bear, which means to carry knives, which is an arm. The text is satisfied. The burden then shifts to California in this case, and they have to show that something like a switchblade is not in common use. But here you have Judge Simons doing it the wrong way. He's saying that the in common use test is part of the textual analysis. Wrong. Then he goes on to say the burden of proof is on the Second Amendment plaintiffs to show that it is in common use. Wrong. Then, to make it even worse, he says that the burden of proof is on the Second Amendment plaintiffs to show that these switchblades are in common use for self-defense. Wrong again. Why do I say that? Look at the Heller case. And this is the problem that the anti-gunners are trying to pretend and desperately trying to get these judges to ignore Heller, because Heller is catastrophic for the anti-gun movement in America when it comes to arms ban cases. So that's why when you see a judge starting to talk about the Second Amendment analysis with Bruen and not Heller, it means you're already going down a bad path. You're already going off a cliff because you got it wrong. So again, once you're starting to talk about the history here, switchblades are obviously in common use, but even if they weren't, even if you could not prove they're in common use, but a million switchblades made a year is clearly in common use, but let's assume you can't even prove that. It doesn't matter. You know what? Because the government bears the burden to show they're not in common use, which means commonly owned. Let's go to the next mistake Judge Simons makes here, which is dealing with self-defense. Okay, this is not hard. If you read the Heller case, and again, Heller is the precedent you apply when you're dealing with an arms ban case, because the Heller case was all about an arms ban. DC had banned the possession of handguns. And therefore, the Supreme Court said you cannot ban handguns in America because they're in common use by Americans for lawful purposes. Now, here's the key. Here's the key. If you read Heller, they don't talk about self-defense in any real respect. They have references to say, yeah, people like guns for self-defense generically, but there's no analysis of it. They don't say how many people did people pull it. And this is important to understand. The Heller case doesn't discuss about how many times did Americans pull a trigger to shoot someone in self-defense. They don't talk about how many times a handgun was brandished in self-defense. They don't talk about how often it's used in self-defense. They don't get into any of that. They literally say that for whatever the reason it is, Americans overwhelmingly choose handguns as their arm, and therefore it cannot be banned for whatever the reason. So here you have Judge Simons trying to get you to talk about self-defense at the textual level, all wrong. And again, he's not applying Heller. I'm not even sure he cites to the Heller case. I didn't see it. Maybe it's buried in there somewhere, but he certainly talks all about Bruen, which again, when you're dealing with the arms ban case, Bruen barely matters because Bruen deals with concealed carrying and licensing issues. Heller deals with the arms ban case, the arms ban scenario. All right, so let me sum up. By the way, I took a quick look. He does reference Heller in a couple places, but he gets it all wrong. But anyway, here's the bottom line. There's going to be appeal here of this. This judge got it clearly wrong. The Ninth Circuit is terrible as a general matter. You might get a good 3-judge panel with like Judge Van Dyke on it or something, and you'll win, but then it'll get en banc. So let me cut to the chase. The only thing that matters for this case of Knife Rights, Inc. versus Bondi is what is the Supreme Court going to do in the Bianchi case? And I think it's changed its name, by the way, but we don't need to get into that. But what is the Supreme Court going to do? Are they going to take the Maryland quote-unquote assault weapon ban this coming term? If they are taking it, let me be clear. If the Supreme Court takes the Bianchi case out of Maryland, which is the assault weapon ban case, all of these anti-gun decisions are toast. Goodbye. If the Supreme Court takes an assault weapons case, we're like 99.5% certain of winning, in my view. It is going to be a slam dunk for the Second Amendment community if the Supreme Court takes the Bianchi case, which they should, but again, one doesn't know. I should also mention one additional thing, and as I said this to many people at the Gun Owners of America event. If Trump wins in November, every one of these Second Amendment cases, in my opinion, we've been talking about just about, we're going to win all of them at the Supreme Court level. Because I think the only thing that is slowing down the Second Amendment movement is ongoing foot dragging at the lower courts, hoping that Kamala Harris will win and that they will be able to swap out Clarence Thomas and Sam Alito with anti-gun, anti-American judges or they're going to expand the Supreme Court and put on a bunch of lefty judges that will just throw out the Constitution, including the Second Amendment. And therefore, a lot of these cases in the lower courts are getting foot dragged to prevent the current composition of the Supreme Court from deciding them, hoping that the composition of the court changes. But let me be clear. If Trump wins in November, it's game over, because that strategy will no longer work, because heaven forbid something happens to one of the justices on the court. You're not going to get a Brown-Jackson justice. You're going to get a Mark Smith or someone better than Mark Smith, right? You're going to get someone like that, right? You're going to get Andy Oldman out of the Fifth Circuit. You're going to get a David Strauss out of the Eighth Circuit. You're going to get a Lawrence Van Dyke out of the Ninth Circuit, right? You're going to get somebody like that to replace a Thomas or Alito or some other justice, which means you're not going to really help the anti-gun movement. And I think on a related note, that Chief Justice John Roberts is going to recognize that if Trump is reelected, that's kind of an election in favor of the Second Amendment, the right to keep and bear arms. I think the Supreme Court is going to feel more comfortable ruling in favor of guns, because they're going to feel like they're on the side. And I know they shouldn't be considering this, but remember, they pick and choose their cases and what they think they should be taking. And if they feel that American history and the current political climate is in favor of the right to keep and bear arms in a robust way, which an election of Donald Trump would be an indication of that, because the anti-gunners have completely embraced the Democratic Party, and the Democrats talk all about guns are bad at their convention over and over and over again. I think that sort of feeling in the air of the political debate and discourse with the Trump election and Republicans capturing the Senate, let's say, will actually encourage the U.S. Supreme Court to resolve all these cases in favor of the right to keep and bear arms. While they shouldn't be considering that, we have to understand that the Supreme Court is in D.C. They do drink the water of the swamp, even if they don't like it. And, you know, I think some of that stuff can influence not so much their decisions on the merits of a case, but I think it can influence what cases they take, because remember, there's thousands of cases that seek cert every year from the Supreme Court to be heard, and they only hear on the merits something like 70 or 75 a year. So they got a lot of discretion as to which cases they hear. So I think it's very good for the Second Amendment if Trump wins, for a whole host of reasons, including the fact, again, I think it eliminates the incentive to slow down cases in the lower courts, because it won't matter, because now the court's not going to change compositionally when it comes to the Second Amendment. So slowing it down in the lower courts won't affect it. And moreover, I think it will embolden the current Supreme Court to take more Second Amendment cases, because they'll feel that they're on the right side of history and even contemporary political concerns. So I think all that is a reason to hope and cheer for a President Trump after November. But again, you know, hey, who knows what's going to happen this election season? But that's just my take of where all this is going to go over the next 6 months. All right, folks, hope you learned something here today at the Four Boxes Diner. We'll bring you more information as this case goes up on appeal. But again, if we win the Bianchi case in the Supreme Court, it's going to wipe out all these cases, and we're going to win cases like this, I think, readily. All right, folks, hope you learned something here today at the Four Boxes Diner. Make sure you subscribe to the channel. Don't forget to follow me on X at Four Boxes Diner. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.